Hello, everybody. Hello, Nigel 1701. Hello, she's a maker. Hello, Ava darling. Hello, Lisette Panette. Hello, C-Rex. Oh, why did you have to jinx me like that? You know that's not a good day for me. And considering the luck that I've had lately. Yes, Ava, you're the star of the show. We all know it. We all know it. Oh, for crying in the mud. Give me 2 seconds, guys. I have to, Owie. I apparently have to, comply with treat requests. There you go. Take the bag too. Don't worry, there's another bag. Oh boy. She's so spoiled. She is so dang spoiled. But we all love her. Hi, Sherry B. I'm so happy you made it. Hello, Nana Laura. Hello, Barbie. Mortimer Duke, my buddy. Hello. That's the only thing Ava can say. Hello, Colette McCoy, my love. Thank you so much for being here. I just love your comments in the comment section. They seriously mean so much to me. And you just have to know that. And same goes for you, Mr. Pork Rinds and Pepsi. Hello, Spider-Man. Welcome. You guys are the best. Oh, that's terrifying. I can make it happen, but that's terrifying. Why would you want to wake up to that every morning? No one else wants to. Hello, Vin7. How you doing, love? Oh, you guys are the best. You make me laugh. You make me smile. Oh, you make me love my life. Thank you. I needed that. Oh, there's a woman tonight. It's after the thumbnail case. But I almost got to use the crying Fez. She took a page right out of their logic. You'll see what I mean. It was so borderline. But I did get to use one of my emojis. Or not emojis. One of my graphics that I designed. I outsource the hard stuff. I do the easy stuff. But I'm so super proud of it. Oh my gosh, I love you. I thought avatars were just the ones that you use as pictures for yourself. Do I misunderstand that, how that works? Because I thought avatars were, you know, when you make those cartoons that look like you kind of thing, and then use them as a profile pic. But, oh well, I made them as t-shirt graphics and merch graphics. We just haven't been able to get the merch store back up and running yet. It's still in the works. I promise someday it'll happen. Oh, well, now we're on level playing field. Just throwing spaghetti at the wall and seeing what sticks. Oh my gosh, you are too sweet. You are too kind. Yeah, well, an image in your likeness, basically. Hello, Sobe Liz. So good to have you here with us. All right, guys, and I don't just have Judge Washington tonight. And I'm going to keep running them until I can't. At some point, I'm going to get tired. But I did have a nap. So hopefully, I'll be able to stay awake all night. At least all the cases that I have.
State of Michigan versus James Robinson, case number 21S00031.
Rachel McDuffie for the people.
Kerma Dadush on behalf of Mr. Robinson, seeking permission to practice under MCR 8.120 under the supervision of Mr. Davilivo.
Thank you. Permission is granted.
Thank you, Your Honor.
We're here for a show cause in this matter. Apparently, there's $1,310 outstanding. Mr. James Robinson, please state your name.
James Robinson.
Thank you.
Your Honor. Sorry, go ahead.
Go ahead.
I talked to Mr. Robinson, and he said that he's going to make a payment of half that amount today once he gets paid around 12:30. He will be making that payment today, and he apologizes for not having made any payments earlier.
Well, he was here on July 11th and made me a promise that he was going to pay this in full, or he agreed to go to jail.
I know, right? But I ain't trying to go to jail. I know. I know. But honest to God truth, when the check cleared about noon, I put in half. We'll go from there. My apologies about that.
If Your Honor would give him one more chance to.
I find that very interesting. Like
I know it sounded good. I really had intentions on it, but things happen. Life happens. You know, and actually I'm paying this out of this is my rent, but I'd rather take care of this, honestly.
I'll see him back here on October 10th, 2024 at 10 o'clock a.m. Sir, if you haven't made a payment on this, you should come in person. Okay?
Okay.
I'm not joking.
No, I got you. I got you. All right, thank you.
I'll make sure he pays, Your Honor. Thank you.
Okay, thank you.
All right.
All right, the court will recall the matters of Sharunda Rochelle Griffin, case numbers 22S00515, 24FB 1104 and 1105.
Rachel McDuffie for the people.
And Your Honor, may it please this honorable court, my name is Bradley Friedman. I appear on behalf of Sharunda Griffin.
Thank you. Permission. Nope, I don't need to say any of that. Ms. Griffin, please state your name.
Yes, ma'am. Good morning. I'm Sharunda Griffin.
Thank you. All right. We're here for sentencing today on these 4 cases. 3 cases. 4 cases. Wait, let me understand something. I think that's what the problem is. You filed appearances on 3 of these cases.
I didn't realize there were 4, Your Honor. I only thought there were 3.
Okay.
I can file an appearance on the 4th. Ms. Griffin has retained me to represent her on all these matters.
All right, thank you. All right. Have you had a chance to go over today's day and time schedule for precedence for the sentencing in this particular case? Have you had a chance to go over the report with her?
I have, Your Honor.
Are you prepared to proceed today?
Yes, Judge.
Thank you. Any corrections, additions, or deletions to the report?
No, Your Honor.
All right. Ms. McDuffie?
Thank you, Your Honor. This is heartbreaking. This is, I know our last case was sad. I don't know why I'm getting this worked up about it. It's not even my case. I mean, it's not me. Here's why this is so sad. Miss Griffin, her violation of probation is for a case that was so long ago. I don't remember if that was from the late 90s or something. Miss Griffin came into the criminal justice system, I think, with one of those original opportunities to sort of change her life, to not end up like this, to get, and this is one of the longest PSIs we've ever had. To see how so much has just spiraled, and alcohol seems to be at the root of almost every single one of these cases. Miss Griffin was in tears when she finally entered the plea on one of the cases in our court, that started in our court, which were driving with a high BAC with her, it was a .284, with her 2-year-old son in the car. I can't imagine what was going through her mind then and now. And to just see that she then tried to run away from all her problems, cut multiple tethers off, and just accumulated more and more. And now she's looking at prison time. I don't know what did not happen where Miss Griffin wasn't able to just get a hold of this. And it's not even just this state. What we have here before us today is enough. It hurts my heart to see. I don't want to say somebody's life thrown away. I'm glad that that baby is okay from the incident that she pled on. But his life is going to be changed forever too, with his mom sitting where she is and eventually, potentially, in a different facility. Ms. Griffin, I apologize for not holding myself together today. But I truly hate to see this, but I will tell you, your life is not over, ma'am. As emotional as even I am as a prosecutor, this is not the end of your life. And even though you may have to end up sitting for some time with all of these offenses, misdemeanors and felonies stacked up, you can still take this opportunity to make a new life for yourself. But making that new life for yourself is not about where you are, it's about who you are inside of here. It's about getting control of your substance abuse problem. Please engage in anything and everything that's available to you. Do it for yourself, do it for your son, do it for your family. These offenses are what you did. They don't have to be who you are. Please make every effort that you can to save your life and then turn it around for your sake and his. And I apologize to the court.
No apologies needed. Mr. Freeman?
Ms. Griffin, yes.
Mr. Freeman, you go first, please.
Thank you, Judge. Your Honor, obviously, the Assistant Prosecutor has said more and knows more about this case than I possibly could. I could only tell the court how I came to be involved in this case. I was contacted by Miss Griffin's husband, who's almost completely disabled because of a severe car accident he was involved in. He's now the sole caregiver for her 4-year-old and 1-year-old child. And he's struggling mightily physically to take care of them, getting them to and from school, daycare, their activities, going to his own physical therapy that's necessary on almost a daily basis. This is a very, very difficult situation. And I know this is a very difficult situation for the court. Your Honor, I would just note that this is a probation from 1998. That's the year I graduated high school.
No, that's the felony.
I know, but that's what she was on tether. Oh, right. She has the OWI also.
She has 4 cases. She
Right.
has OWI and cutting off her tether 2 times.
I know. And I think that, and I might be wrong, but the tether was placed based on bond violations for the or probation violations maybe for the 1998 case. I want the court to understand that I do believe that my client, although she's now been sitting in jail since the beginning of June, is in a place now where she can have a more profound understanding of the effect that she's had on her children's lives and on her life. 3 months, albeit it's not 5 years or whatever the recommendation is in circuit court, it's a significant amount of time in jail. I would note that during that period of time, she's been engaged in MRT. She's scheduled to graduate and finish MRT this week. She's also received 3 good time cards. She's doing whatever she can to make use of her time in jail. I spoke to Judge Conlon relative to the circuit court case. I convinced him not to enter a sentencing order or not to sentence her last week when we appeared in front of him, and instead give me the opportunity to plead to you in this court to see if you would possibly consider any situation where you would put her on court supervision. I'm sincerely hoping that you would consider that. I know that there was a recommendation for her to enter into another program in the jail, but I know they also have an intensive inpatient treatment. I don't know if she needs to have private insurance to get into that program, but I would know that I think that my client has, certainly she's an alcoholic, that's clear, and she has severe problems with alcohol. But she also has a diagnosis for bipolar and depression. And I know, Your Honor, this is my first time appearing in front of you, but you undoubtedly know, just by your experience, even just on the bench, that alcohol and mental illness is a major, major issue in the criminal justice system. I'm just saying that I'm hoping that the court will, instead of just telling my client that because of cutting off her tether and ignoring court orders in the past, that she's destined just to go to prison, on Judge Conlon's circuit court order. I'm hoping that you don't just give her jail time on this case and let Judge Conlon, or have Judge Conlon with no other choice really than to send her to prison on his case. I'm really, really hoping, and I know Miss Griffin wants to speak to you on this herself. I don't want to tread too much in what she wants to say, but she's got nothing left but to throw herself at the mercy of the court and to see if the court's willing to give her one more opportunity, because she's had several, to give her any chance at not going to prison, a chance at possibly getting back to her children and helping her husband sometime relatively soon.
Her charges are that she drove with a blood alcohol content level of 0.284, I believe it was, with her child in the car. That's as much as I know. They may get into the actual details of it a little later in the sentencing, but that's what we're looking at here. And she cut off 2 tethers. She absconded. She's not a good candidate for probation. And so all of these charges are now just coming back to her at once.
She's willing to do whatever it takes. And I think she's really honestly at a point. And obviously, I'm not going to speak for her. I want Your Honor to ask her to speak in her own words. But I think she's at a point now where she's really conceding to her issues, both the alcoholism and the mental health. And she's really ready to aggressively approach them and appreciate that they're going to be parts of her life, probably for the rest of her life. And these are demons that she has to battle forever. But she hasn't been in a position, at least as far as I know, up until now, that she was able to have any community support for the alcohol and the mental health. I know since she's been in jail, she's been on psych meds. She's been seeing the doctors and nurses, and she's trying to deal with her mental health issues. I'm just asking the court to allow her to be on monitoring with Your Honor, put her in inpatient treatment. I don't know if it's Naomi's Nest or if there's any other place where you can send her to, but she's asking for one more opportunity to try and deal with her demons and face her demons, with the hope that, again, like I said, she can get back to her family and her children, and they can, she'll be able to be a good mother and a good wife, because before she deals with her issues and her problems, she's not going to be able to do that. And I would just assert, Your Honor, the last thing I'll say is this: she's not going to get the help she needs in prison. So I'm really hoping that you'll give her this one last opportunity. And I'm not asking you to make her probation light in any sort of way. I'm just asking you to set it up in a way. I don't know if there's a sobriety court or anything, but I'm asking you to give her one more opportunity to show you that she's going to be committed to get herself better. Thank you.
Before I listen to your client, I have a number of concerns based on what you just said. One is, even if I gave her 1 year in jail, it doesn't mean the judge has to send her to prison. Why can't he just do 1 year in jail? I don't understand that concept. Having done this work for almost 30 years before becoming a judge, I don't understand what your argument is. I don't understand how that works.
My argument is that if Your Honor would give her a structured sentence, which requires that she go into inpatient treatment, that she receive significant mental health treatment. If there's a place for inpatient that has a dual diagnosis program, that she go into that you place her on.
I understand what your request is. I'm trying to understand how you're making the argument that if I gave her 1 year, she therefore had to go to prison.
No, I'm not asking you to give her any prison time, any jail
I
time.
know you're not. I know you're not. But what you're saying to me is if I give her jail time, therefore she automatically goes to prison, and I don't agree with that
Oh,
statement.
no, that's not what I'm saying.
Okay.
That's not what I'm saying. I'm saying that at the district court level, I believe you have an opportunity to give her more of a hands-on approach in terms of your sentencing and her being on probation. Much more so than I think the circuit court would be willing to do, or frankly, would have docket time to do. I'm asking you to put her in a program, and I apologize. I'm not fully familiar with what sorts of dual diagnosis programs.
I understand. I understand that part of your argument.
But that's why I'm just saying, in my conversation with Judge Conlon, I indicated to him that I was hoping that if you structured such a sentencing, that he'd be willing to sort of ride along with it. Not that he would dismiss her case. He would still be holding the prison time over her head, but that he would ride along with whatever sentence Your Honor would come forward with. And obviously, if she screws up for you, she screws up for him too. And she still has to do the full extent of prison time that he has available to him in her
What are her
sentence.
sentencing guidelines on the prison case, on the felony case?
Your Honor, I don't have that file in front of me. I'm sorry. I don't know what the full extent of her guidelines are. I do know that the recommendation indicated in the pre-sentence report for this case, and I know the probation officer might be able to speak to that better than me, but it was somewhere in the neighborhood of 5 years in prison.
I know that's what they said they were going to be recommending, but I wanted to understand the actual guidelines to see what the court's options truly were based on the guidelines.
I can tell you that the underlying offense was unlawfully driving away an automobile.
The other issue I have, your argument is that essentially I shouldn't punish her for something that she did in the past. I'm not looking at what she did in 1998. I'm looking at what she did in 2022 and 2023. I mean, at those particular points in times when she made those choices, she already had the issues that you're presenting to me today already ongoing. She already knew that her husband was disabled. She already knew that she had children because she was driving in the car with the children in the car at the time. Now, I say all that with the understanding that I know that substance use is a disorder. It is a disease, and she was suffering from that disease. But I have never seen anyone who has taken every opportunity they've been given and immediately throw it away. She cut off every tether to send a clear signal to every court that she does not care. And so today, because she's been sitting in jail for a while, you want me to say, give her another chance, but I'm not feeling that. So I'm going to hear from her, see what she has to say, and see if she can convince me otherwise, because right now, all I see is someone who has dual diagnosed issues, understood, I see that a lot, but not that just those issues. They were not given one, but two opportunities to show the court that they could, in fact, comply with bond conditions or do something to try to help themselves. And they basically said, I'm going to punch you in the face with that opportunity that you gave me and cut off your tether. And some of them, we don't even know where they are. What do you have to say, Ms. Griffin?
Ma'am, Your Honor, first, I just want to apologize to you, the courts, Ms. McDuffie, to everyone involved in this case. I understand completely what you're saying. I don't want the court to think I don't have no respect or, I know the way it looks. but I know the way it looks. I really want help, Your Honor. I really want help. I really want help. I've been getting help with my mental illness that I've been suffering with since childhood. I've been getting help with that. I've been clean and school.
I didn't catch the last part of what you just said, Mel.
No, ma'am. I was just saying that I'm sorry. I've been getting help as far as my mental health. I've been seeing the counselors and I've been in my MRT classes and everything, and I've been seeing the psychiatrist, and they've been regulating my meds as far as my mental health has been going. As far as my addiction, I do want help. Like, it's hard. It's hard, definitely, to try to do it by myself. It's hard. And I do want the help, and I see all of that now. I see all of that, and I feel like, I was messed up then. I was messed up then. I was going through a lot, not making excuses, but I lost my mom, my dad, and it was just like I was taking care of my kids, my adult children, and then I had my little babies. And then my husband got in his accident in 2023, and that's what disabled him. And being in jail, I've had to sit and even dealing with the classes. Well, with the classes, I've done a lot of work looking back and evaluating my life and seeing that, I need help. I need help. I do, and I don't want to go to prison. I don't want to be away from my babies. I would have to, I need to be there for them and my husband as well. But I know I need to get myself together as well. I just need another chance. I know how it looks, Your Honor. And I apologize to you and to Judge Conlon and Ms. McDuffie, I'm sorry, the prosecutor, the probation department, and everybody. I just need help. I just need help. I want to be here for my babies. I've been away from them now, and I'm not making no excuse because I probably, it's not a probably. I know I deserve it to, be where I am right now. But I feel like I'm working on it, and I want to work on it. I want to get better, to give my little babies a second chance, to be a better mom to them than I was, even to my adult children. I want to be a better person for myself. And I want to prove to you and to the other judge, to Mr. Conlon, your Judge Conlon, to Ms. McDuffie, to the probation department, to my kids, even to Mr. Friedman, that, I can do this. I can do this. And I'm ready to change. I didn't have any hope at first. I'm sorry, I don't want to take too much of the court's time. But I do really, genuinely, from my heart, apologize, and I beg for mercy from the court.
And when you were given the tethers, can you tell me what was going through your mind when you decided you're going to cut those off?
Well, ma'am, one of the times I was pregnant and my ankle swelled up. One time I was just completely out of my mind, and I don't know if it was my because I wasn't on my psych meds, and then it was a lot of alcohol and stuff involved, and so but another time it was due to medical reasons, because I do have a seizure disorder, and I went into cardiac arrest, and I have heart problems, and then I have swelling. I had a lot of fluid on my body, and yes, ma'am. But the other time, I can't make any excuse for it. I can't. It was just my addiction and my mental health. It definitely was. Yes, ma'am. And I knew the consequences. I know now. I would never, so, as clear-minded and stuff as I am now. And I've been doing a lot of, even reconnecting with my spirituality and everything like that, and just evaluating my life and stuff. I would never have done that. I knew it was definitely Mr. Freeman made a point with it was like demons. It was like a dark cloud, a dark period in my life. And it's been there for so long, and I just really need help. I really want the help. And I'm really, like, I'm taking as many steps, and I will do whatever I have to do. But I want to prove it to, everyone, to you guys and my children as well. I want to get my little babies at home, a second chance to get to know mom, and to know who I am without alcohol, without it's hanging over my head. I don't want to put them through this. It hurt my heart when I got in trouble with my 2-year-old son. He's 4 now. He's 4 now, and then I have a 1-year-old. They're whole too, and I don't ever want them to. I was just really messed up. I was. And I really want to prove it to them and to you guys as well as to myself. I don't want to go to prison, ma'am. I want another chance. I want to prove it to everybody that I can do it.
All right, thank you. Anything else from you, Ms. McDuffie, before I impose sentence?
Your Honor, I'm not aware of any sort of potential preliminary COPS conversations that might have happened with Judge Conlon in circuit court regarding her prison time. All I see is that that's what the agent was looking at. So I can't really speak to that. I don't take any position on Miss Griffin keeps saying she needs help. We know, we believe her. We clearly she needs help. I think the trouble that we're looking at here is that it wasn't just that she said she's not making excuses, and ultimately it was her addiction and mental health problems. But regardless of the circumstances of what led up to her cutting off both of those tethers both times when she was already in violation status, she didn't contact community corrections to report those issues. She absconded, right? So it wasn't that, hey, I need help with this. It doesn't fit well. It's causing me pain. Can you adjust it? It was cutting them off and being out MIA and disconnecting from the court to try to run away from these cases and these issues. And I don't know how we can send her. Of course she needs treatment. Of course she needs long-term treatment. But how can we send her somewhere with a tether to make sure she stays there when she doesn't yet have the skill set to not do that again? When all we can do when we trust somebody to be out of custody is to have a tether and basically obey those conditions so that we can track them and so that we know where they are. And if you've proven repeatedly that you will cut it off, and you're in such a situation right now where you need so much help, I don't know that Ms. Griffin is going to be able to keep another tether on. And I don't have these are other offenses in Mississippi and Tennessee, I think. I don't even know what the timing was for those. I'm truly concerned about her absconding again, and that's in or out of state. So I don't disagree with counsel that she clearly needs treatment, but I feel like we're in a difficult position on trying to figure out how to deliver that in a secure way. That's all.
All right. So, Mr. Friedman, since the defense gets last, I'll give you one very brief opportunity to respond.
I'll be very brief, Your Honor, and I would just say, what's the alternative? Just wash your hands of Ms. Griffin. Judge Conlon does the same. She goes to prison for 5 years, comes back out, receives no treatment whatsoever. I don't see that as being the right result in this case. Again, I would just say to the court, I know she's violated. I know she cut off her tether. I don't think either time she was under court supervision on probation. I think both
times she was on court supervision.
I thought that was for bond. No,
one time for certain she was on probation.
Okay. I would just say, if there's anything the court knows of, and the court's going to be more knowledgeable than me, where she can be on tether so the court's at least knows where she is and she's not drinking, and she can be in some sort of significant dual diagnosis program. That's really, really what we'd be asking for. I'm not asking you to be lenient whatsoever with her probation. Any false step and she's done. But I'm just asking you to give her that one chance.
So this is where I am with this. She's had plenty of opportunities to do probation. I'm not doing probation for her. I don't see that as a viable option because she's shown us time and time again what she will do with that. She has cut off her scram tether on not one, but two separate occasions. And I don't see a way around that. Unfortunately, trust someone when they show you the first time who they are. We didn't do that. We gave her another chance after that. And she did it again. So I've been sitting here as everyone talked to try to figure out, can I come up with something for her that gives her what she needs so that she doesn't do 5 years in prison. And I don't think that it's really going to fall on me anyway. I think that ultimately it's going to be Judge Conlon that's going to decide what he's going to do about her. And I think that the best I can do for her without subjecting this court or any other agency to another significant loss, because those tethers cost so much money, is to allow her to serve her time in jail and release her to a treatment program, which I'll do. And if the probation, and I'm not putting a GPS tether on her because I don't think it's gonna matter. If she leaves that, she'll come back and she'll finish serving her time. If that's not significant enough for Judge Conlon to feel she shouldn't go to prison, then that's not significant enough. But that's the best I have for her. So that if she really is truly trying to get her treatment, this will be probably her one and only opportunity to do it if Judge Conlon goes along with it. And if he doesn't, and he sends her to prison, then that's between the two of them. But at this point, I'm not trying to put a tether on her because I don't think it's gonna matter. She's shown us that she'll just cut it off and do what she wants to do anyway. I'm gonna allow her to be released to an inpatient treatment program that provides dual diagnosis. So she's gonna have a couple of hurdles. One is finding a program that does dual diagnosis, and two is seeing if Judge Conlon is willing to go along with that particular program. But I'm not gonna have her on probation because she's shown that she has no real desire when she's out to do that. Everyone sitting in jail all of a sudden finds an opportunity for them to be a better person and it's gonna do better. Based on her behavior while she's out, I don't trust it and I'm not going to agree to it. And hopefully she'll do what's right for herself and her family. If she doesn't, then she'll end up in prison for a much longer time than 5 to 10. So it is the sentence of this court that in case number 22S00158, she served 90 days in the Washington County Jail, credit for time served. In case number 22S, and the other thing I'm doing for her is this. I don't have to give her credit for time served because in reality, she's on PR bond on at least 2 of these cases with me. That's the 24 FB 1104 and the 24 FB 1105. So I could technically give her 365 and just make her sit there for the entire time. But I'm not gonna do that. I'm gonna give her this opportunity, but this is the best I got for her. And if she says she's learned anything, I hope that she acts in that way and that she does what she's supposed to do. 22S00515, 365 days, Washington County Jail, credit for 114 days served. 24 FB 1105, 365 days, credit for 106 served. And 23 FB 1105, 365 days, credit for 102 served. In each of the cases in which she is going to do additional time, she can be released to an inpatient program that provides dual diagnosis.
Excuse me, Your Honor, you said the 365 days I would have to do those and then go to the dual diagnosis?
No, I didn't, and I'm still saying, so please wait.
I'm sorry.
To be released to an inpatient program that provides a dual diagnosis for both mental health and substance use disorder. If defendant does not successfully complete that, she is to be returned to Washtenaw County Jail and complete that sentence. So, ma'am, what you're gonna need to do, and I'm gonna do something that I don't normally do, is I'm gonna schedule a time to see where you are. Because I'm serious. You've been given so many opportunities, and every time you sit in front of one of us, you give us that same story about how you're gonna change. That's how you end up being given an opportunity to be on Scram and all of that, and you just don't do a thing. You just go back to doing the same thing you do every single time and show us over and over again that you don't mean it. So I'm gonna schedule this for December 12th, 2024 at 10 a.m. Counselor, if she gets out and she's completed a program or she's in a program, you need to get me that documentation before that date.
Okay,
If I haven't heard from you and I haven't heard from her and she's out, I'm gonna issue a bench warrant because I'll believe that she hasn't done what she's supposed to do. Because
Okay.
Against my better judgment, I'm giving her this opportunity. It's not what you want, but it's the best I got. Okay?
we appreciate that, Your Honor. Thank you.
Thank you so much, Your Honor. Thank you so very much.
You're welcome.
Thank you to Ms. Duffy.
Take care.
Judge Washington had her fill. She was done. You can only give so many chances, and they keep asking for a second chance. But it's not the second chance. Every time she went in front of a judge, she was given more chances and more chances and more chances. I really hope that she does get the help that she needs. Not just for her sake, but for her children's sake and for the innocent people on the road. Because that could have very easily resulted in a vehicular manslaughter or vehicular homicide charge. Very easily. Now we get to go watch someone, like I said at the beginning, she's taken all of her logic from the subsidiary theories. She's not exactly a subset, but she's so on that line with this logic anyways.
Court will call the case of Absolute Resolutions Investments, LLC versus Patricia Robinson, case number 24C 1841.
Good afternoon, Your Honor. Michael Bankstein, P69778, on behalf of Absolute Resolutions Corporation.
Good afternoon, Mr. Bankstein. Ms. Robinson, please state your name.
Yes, hi, this is Patricia Robinson.
Thank you. Good afternoon.
Good
All right,
afternoon.
we're here for a pretrial as well as a motion for summary disposition today. Ms. Robinson, have you received the motion for summary disposition?
The motion for summary, yes, I have.
All right. Do you understand what that is, ma'am?
I understand from what I've read. I didn't read the
What is
entire
it that
thing.
you think you understand?
What is it that I don't understand about
What
it?
is it that you think you understand, ma'am?
That it says here, the plaintiff Absolute Investment LLC, hereinafter the plaintiff
Okay.
has filed.
All right,
a
never mind. Let me tell you what this all means, okay?
Okay.
They filed a motion today, basically saying that you lose, that you don't have a defense to this action, and that they want to get a judgment against you today. That's what that all means. Okay?
Oh, but that was without me? You guys
That is
met
what
without
that
me.
means, ma'am. That is what that means.
Okay.
And you had an obligation to file a response to that within a certain time period, which you
I
did
did
not.
file a response.
When did you file your response, ma'am?
I did.
When did
I
you
was-
file a response to their motion for summary disposition?
I filed a response June the 21st.
And this was filed on August.
Your Honor, I may be of assistance.
Please.
Defendants frequently mistake the answer and a response. The answer to the complaint was filed, but we've received no response to our motion for summary disposition.
Oh, I wasn't aware I was supposed to respond a second time. It
You
didn't
have to
say like the
respond
first
to
time.
everything. Well, that's the reason. That's the problem with trying to represent yourself, ma'am, is that people don't understand the court rules. The court rules provide that you have to respond within a certain number of days to a motion for summary disposition, and you didn't do that.
Well, the first one was clear. The first one was very clear that I had.
I'm not here to argue about the clarity of this or what the laws are. I'm just telling you what it is.
So what was I supposed to
I
respond
can't
to?
give you legal advice to the motion for summary disposition. I've said that like 3 times.
Okay, it doesn't say here that I'm supposed to respond within a certain amount of
Ma'am,
time.
one more time. You are, as a person representing yourself, supposed to respond based on the court rules, and no one can give you legal advice about that. That is what you're supposed to do. You're held to the same standard as a lawyer when you don't have one. So that's why I'm trying to explain to you what that document is so you can fully understand the position you're in. I'm not here to argue with you about it. I'm trying to explain it to you.
Okay, I appreciate that.
So, knowing the position you're in here today to the motion for summary disposition, do you want to talk to them about trying to reach some type of resolution on this issue, or what do you want to do? What is your position to the motion?
What is my position? I am not indebted to this company. I don't know who they are. And that's what I was talking about. I don't have an account with them, or they created a fraudulent account. They said on the second page of the motion. That's what I thought I was responding to the letter today. That
Not a letter, ma'am, it's a motion.
On the motion. And I thought I was responding today to talk about what I'm reading here. And so, it said that the account was used, and I don't see any evidence of that. It said that there was activity. I don't see any activity.
And that's all, they provided you with statements. Do you not see the statements?
Yeah, but it says activity. That would be some purchases.
That's activity, ma'am. The statements show you the activity.
Yeah, but there's no purchases.
There's no what?
Purchases. A purchase is an activity. Did you see that? Like on any of the statements, a purchase is an activity. They said that this account was used. I didn't use it. It says activities, and to not just that, I'm not indebted to this company. I don't know who.
Which one is your defense, ma'am? I need one or the other. Are you saying you didn't make a balance transfer of $416 on this account back in June of 2021, and a balance transfer of $4,340? Are you saying you didn't do those things, or are you saying that it's not you? I'm not sure which one.
What I'm saying is that I'm being sued by.
Ma'am, I know who you're being sued by. Please answer my question.
And I am not indebted to them. No, I don't owe them anything.
So are you saying this? Okay.
I don't owe absolutely anything. I don't have an agreement. I don't have a contract. I don't see anything with my signature on it.
All right. Thank you. Mr. Binkstein?
Thank you. Again, our office did not receive a response from defendant to our motion for summary disposition. Without belaboring all the points in the brief in support of our motion, I do want to bring up a few highlights. Defendant opened the account, made purchases and payments, then stopped paying on the account.
She's saying she did not, so I want you to address that. She's saying
Well,
she
that's part of it. There's more than
Okay.
just one sentence. It's going to be a comprehensive response. Defendant opened the account, made purchases and payments, stopped paying on the account. Those statements went to her address, never objected to the statements. There was activity on those statements. There's payments being made. A payment is an activity also. I'm not clear on why somebody would make multiple payments on an account that they also say they don't owe on. It does appear that defendant is making some sort of privity of contract argument. I noticed she very carefully words it, I don't owe Absolute Resolutions Corporation. Absolute Resolutions Corporation was not the originator. But we have attached documents that show the chain of title. I mean, privity of contract was a great argument about 120 years ago, but that's not the rule anymore. This stuff is fungible. If you have a contract with somebody, that someone can sell the paper to someone else. And that's what's happened here. Defendant has not demonstrated that there's any material issue of fact in dispute, and plaintiff is entitled to judgment.
You use a lot of big words that I'm sure she doesn't understand many of them. What do you mean by?
But I understood one thing, Your Honor.
Ma'am, please don't
But I
talk over me.
objected.
Ma'am, please don't talk over me.
Oh, I'm so sorry.
Mr. Bankstein, when you say privity of contract, what are you saying, sir?
Well, it's right in her answer. I mean, I'm basically just, let me pull the answer up. I mean, I'm just, presumably she understands what she put in her answer. So I'll pull the answer up. Give me a second. Just
You're
scrolling
talking
down.
about the assignment of the debt?
I'm just scrolling down to the answer. I'm just trying to address the points that she's brought up. Give me 1 second. I think I'm just about a page away from it. No paperwork that's in her name showing an assignment of a debt. I mean, there wouldn't be anything that she would have signed. We do have a letter from the originator saying, hey, we've sold your debt to these people. And we have a debt from, we have a letter from Absolute Resolutions Corporation saying, hey, we're the ones who it's paid to now. I mean, that shows the assignment. She may object to the assignment. She may not like that there was an assignment, but that's not, the debtor is not required to sign off on an assignment between two companies. I mean, that's something that was sent to her. She never objected to that. It's to the same address that she has now, I believe.
And which part of your exhibits is the assignment in, Mr. Bankstein?
That would be Exhibit B. There's a letter from regarding her account. It does have her account number on it. It does, in fact, have her name on it. It does have the balance. And it says that we're going to stop accepting payments, that now it's been transferred, and you now send payment to Absolute Resolutions Investments. And then defendant also received a letter from Absolute Resolutions Corporation saying, please take notice that your U.S. Bank DBA Elan Financial Services account has been purchased and assigned to Absolute Resolutions Corporation. Again, it has the account number. Again, here's where you send the payments.
And you're talking about Exhibit B with the date of December 28th, 2023, with the transferred balance of $4,343.31, correct?
That's correct, Your Honor.
Okay. All right. Anything else from you, Mr. Bankenstein? Thanks.
I have nothing further other than what we've already discussed and what I put on the record, Your Honor.
All right, thank you. Ms. Robinson? Anything from
Okay,
you,
Your
ma'am?
Honor. I'm sorry, what was that?
Is there anything from you, ma'am?
Yes. In response to what you just said in Exhibit B, and I did look at that letter, or line, the third, number 3. It says absolute.
Oh, wait 1 second, ma'am.
I just can't hear what she's saying.
I muted her by accident. I was trying to stop her video so I could hear her because she was lagging, but I muted her. Can you hit unmute again, ma'am, please? I'm sorry. All right.
Okay.
I'm going to stop your video, ma'am. Thank you. Go ahead.
Okay, so the attorney said that there was a title transfer. And on number 3, it says Absolute Resolution Investments may not transfer title to your account.
Number 3 of what? I don't know what you're referring to, ma'am.
In Exhibit B that he just pointed out, that the letter, and the letter states here that they're just, that this was a transfer. Your Honor, I read in 33.9.901, the article about collection agencies, that they're supposed to be connected to this company somehow, the original creditor, like an employee, like they're doing this on behalf of them.
That's not true, ma'am.
May I point that out? Exactly where it's located, because I did read that today.
You can point out whatever you would choose, ma'am.
Okay. Okay, so in the definition for the occupational code, this is the Act of 299 of 1980. Under the 3.901, it says the collection agency. And I guess I don't know if he's considered an attorney or if this is considered a collection agency. But if you read down the paragraph, it says has been employed to collect. And unless this company is employed to collect, or they have some type of a title, they shouldn't be collecting from me. I am not indebted to them. There is nothing in this letter that said that a debt has been transferred. A debt. It doesn't say a debt. It says account. Account and a debt are two different things, Your Honor. That account means that there's some type of a contract of assignment that I signed between me and Absolute. And there's no, they open up an account without an agreement. And to me, that's fraudulent. So that's what I'm saying. So I am not indebted to Absolute. They're saying that I'm indebted, but it's showing that I am not indebted because there's no contract. They didn't show me any contract that I owe them anything. There's no contract that I owe Absolute.
Response to her.
Paperwork.
Go ahead.
I'm sorry, you guys were talking over each other. I missed that last bit.
I told her to go ahead.
I see no paperwork that shows that I am indebted to Absolute. And that's what I've been looking for through all the paperwork that I looked at, through all the statements that they sent. I'm seeing the original creditor in which I'm indebted to them because I signed a contract. I did not sign a contract. And this letter does not state that it just says that they transferred. It doesn't say that they gave, any type of debt that I owe this company. It says here on the letter, your new owner and servicer, Absolute Resolution Investments, will immediately start accepting payments. Who are they? There's no agreement to with this company. It's just a letter. It doesn't show that I owe any type of debt.
Right, thank you. Any response?
And unless they come up with a contract that I signed something, agreeing, some type of agreement, I don't owe Resolute. I'm done.
All right, thank you. Mr. Bankstein, any response to that?
Yes, first of all, a response and any evidence attached thereto is due by 7 days prior to the hearing. Again, defendant just, I guess, feels she doesn't need to follow the Michigan court rules. But despite that gotcha moment, I wasn't able to find the site that she was citing to the occupational code. I wasn't able to find where it says that. Also, defendant appears to be under the belief that for one company to transfer the debt to another company, that it requires her agreement, and that simply isn't the case. She got a validation notice from our office. She got the letter from Elon. She got the letter from Absolute Resolutions Corporation. Never objected to any of those letters. Never objected to the validation notice. Clearly, those are contracts. Statements that were sent to her address. Never objected to those. She made purchases and payments. There may not be purchases showing on that account. But there were payments on the account. I believe that we've more than met our burden of proof, and in the complete absence of any evidence provided by a defendant, I'm asking the court to grant our motion for summary disposition.
Thank you. The court has had an opportunity to review the motion for summary disposition in this case, listen to both the moving party and the non-moving party as to the issues before the court. This is a C9, C10 motion, and basically the court has to look at whether or not there's a defense to this claim. The defense being asserted is that the notice of assignment of the sale or transfer of ownership rights was not proper because the actual person liable for the debt didn't sign it. That is the absolute opposite of what the law is. That is not how the law works. The company that you entered into agreement to, much to many people's dismay, have the right and the opportunity to make that assignment. That notice was sent to her that it was assigned. It was sent out on December 28th, 2023. It looks like the parties read into the record only the first page of that notice. The second page of the notice indicates that you are hereby notified that the servicing of your credit card account, that is the right to collect payments from you, is being assigned, sold, or transferred from Elan Financial Services to Absolute Resolution Investment. And clearly gave the notice that is provided under the law that needs to be provided. The motion for summary disposition is granted. I will sign an order to that effect. I have it in front of me and I'm signing it now.
Thank you, Your Honor. Have a great day.
Thank you, you too.
Oh my gosh, that one was so much fun. Billy, you've got my finger like twice now. Calm down. These people are going to think I never feed you. Get off the computer. Oh my goodness. They never said how much was owed. Wait, maybe they did at the beginning. I don't remember. You'll have to go back and watch it. Watch it again. And again and again and again. Do you just take it? Right? That's anything food for these guys. No, no, that would be really wrong of me. No, it's a Temptations Prey. This one's chicken. And since there's two cats splitting them, I always do give them two. And I do try to be fair and make sure Earl gets his share. All right, guys, I'm going to put another case on. We had to have a little bit of kitty time. Oh, let's get ready for some fun family drama.
We're now live streaming on YouTube. This is Judge Dulce Madrigal. I'm hearing cases today for Hays County on Thursday, September 12th, 2024 by Zoom. I will now call the cause number 210529, present are both the non-custodial parent and custodial parent. Mr. Acco, go ahead and announce yourself with your full legal name.
Call by Fairman Uncle.
Thank you, and same for you, Ms. Garcia Acco.
Tina Marie Garcia Acco.
I need to swear you all in. If you raise your right hands, both of you for me. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, starting with you, sir?
Yes.
Ma'am?
Yes.
Okay. You're aware that I'm an associate judge. I've been appointed to hear the cases filed by the Attorney General's Child Support Unit. Let me move on to Mr. Asif. You've got an opening statement, I assume, for me after announcing yourself, sir?
Yes, Your Honor. This is Maz Asif for the state of Texas. We're here today on the state's suit for modification of support order and motion to confirm support arrearage. Before we get started into terms, I want to discuss the matter of arrears. The state has submitted to this court the financial activity report for this case. And the state's
Did you send it by email?
Yes, Your Honor.
Okay, I'm not there yet, but when I need to review it, I will take judicial notice that you sent me the pay record. If you want me to review it, you might have to screen share it as the quickest way. Otherwise, I have to stop and open my email and go look at it myself.
Yes, Your Honor.
Go ahead.
So the state will be asking for a judgment. The state is requesting a judgment on arrears as of August 31st, 2024 of $7,298.71 to be repaid at a rate of $91 a month, with payments to begin on October 1st, 2024. Mr. Acco is not in agreement. He feels he should not have to pay this amount. Ms. Garcia has issues with the judgment date. She wants a judgment date as of September 1st. Okay. Now, with respect to the medical,
why would that matter at all? Do you have any idea, Mr. Asif?
I'm not sure, Your
Honor. Excuse me. Okay. Ms. Garcia, you don't get to dictate what we do here as far as dates and what have you. You don't lose one single penny whether I do it August 31st or September 1st. September 1st has the new accrual amount, which is, yeah, it might be due if it's due on the 1st, but it's not considered delinquent till the 30th or 31st. And at the end of the month, the interest accrues. So we go to August 31st, they put it on their computer. You haven't lost a penny because September 1st, they'll put the new amounts and it keeps rolling. The computer keeps track of all of that and with interest at the end of every month if there's arrears. So I'm not sure why we're going to have a fight about that, but I just want you to be aware of what the situation is before I cut you off on that, because it doesn't matter what you want and you don't lose a penny. So Mr. Asif, go ahead and finish your opening.
Yes, Your Honor. So with respect to the medical support issue, both Ms. Garcia and Mr. Acco would like the child to be on their health and dental insurance. Ms. Garcia is requesting that the child be on her dental insurance, and then Mr. Acco be ordered to pay cash medical support of $792.08, as well as
cash medical support of how much?
$792.08, Your Honor.
Is that anywhere near the 9% cap or above it?
The states understand. Mr. Acco's position is his gross monthly resources are $3,648 before tax. Based off of that, the 9%, the max if that is true, the max we'd be able to charge for cash medical support would be $328.32.
So there's a dispute about his income, according to.
Yes, Your Honor, there is a dispute.
And is there going to be any real evidence on that, or is it just going to be that he said, she said?
I believe Mr. Acco has a pay stub that he's submitting to the court.
And what does Ms. Garcia have?
I'm not sure, Your Honor.
Are you prepared to show any evidence of whatever you think he earns, ma'am? Or is it just?
Am I prepared to show? I know absolutely nothing about what he makes, but what I do know is that he has 30 years in a field where he is more than capable of making what he was previously making, if not more.
Okay.
So for him to go and take a job that's less paying than what he was previously making, how is that fair?
Okay, so you're going to be alleging that he's underemployed because somewhere along the line there is proof that he made more. Is that what you're saying?
honestly, I have every reason to believe that he was working 2 jobs last time we were actually in court.
This isn't going to be no 45-minute case, people. And Mr. Acco, if I do agree,
Yes.
if Ms. Garcia prevails and you have the right of appeal, will you be appealing my decision to a higher court, the district court level?
Yep.
Ms. Garcia, if I don't rule your way and Mr. Acco prevails, will you be appealing to a higher court to the
Oh,
district
I'm
court
not
level?
giving in because I'm the one that has been doing everything that a parent should be doing.
Okay, then that's your right and that's your obligation and advocacy, but it seems to me it'd be a waste of my time today to give you 45 minutes, cut you short, and you don't get to tell all of it, and then you lose, one of you's gonna lose, and then you're gonna appeal me anyway. I'm not sure I wanna hear it. Mr. Asif, is there any reason I shouldn't refer it to district court? Because these folks, I believe, if they've been here several times, it's not over with whatever I decide to do today, it looks like. So they're adequate advocates for themselves. I don't see why they can't
Sure.
just take it to the district court level and let somebody up there.
Yeah, Your Honor, the state has no position on that. We're not in favor, nor do we object to a referral to district court.
You know, I usually don't send pro se's over there, but if this is that contested and that what's the word? Well,
Your Honor, if I may, perhaps we could get some temporary orders prior to the referral.
we don't even have temporary orders yet.
We
You
do
have
have temporary orders in place, but perhaps we can amend the terms to reflect the current situation before referring upwards.
Well, I would consider that if we can squeeze it in the next 40 minutes.
And the word is contentious, Judge. Contentious.
Okay. But for a final, I would refer it. I'm not hearing this dispute with the right of appeal where y'all are going to go somewhere else anyway. So I'll let you go there and have one bite at the apple for the final order. Okay, proceed on whatever issues I need to decide on the temporary orders, Mr. Asif.
Your Honor, there's also some complications here. It's my understanding that Mr. Acco lives in Hawaii. He won't be able to remotely appear in district court in Hays County. So that might be somewhat problematic if we refer to district court. Also, I'm not convinced that the issues are sufficiently complex. That we have some dispute over income, but we can subpoena Mr. Acco's pay stubs and W-2 forms and get to the bottom of that issue. I'm thinking a reset with a priority hearing would be more appropriate.
I would agree with you at this late hour. Did you all get that?
So on that level, y'all.
Let me start with you, Mr. Acco. Did you get that?
On that, yes, but on that level, if I'm making a certain amount that I'm making with my new employer, am I still responsible to pay that $915 a month, which I don't make as much as I did at Whole Foods?
Well, that's the question. The problem is that if you have a history of prior employment at a higher level, why should it go down if the argument would be you're underemployed? So I'd have to hear that reason.
It has only gone down by $6 per hour. It hasn't gone down drastically. I make $22.15 an hour, and at Whole Foods I make $29 an hour. So it's only went down $6, $7. It hasn't gone down drastically on my pay.
Well, I haven't done the math, so I don't know how much $7, roughly $7.15 difference would result in child support, because it adds up 40 hours a week for 4.3 weeks per month. So I don't know, sir. So Ms. Garcia, are you saying one or the other is the right number, or those are both totally off because he does something else that you think he should be doing at this time?
Whenever he has a trade in a certain career, or we were together for 22 years. And he was doing that even before we met each other. He's been doing it ever since we've been divorced. So you're looking at about 30 years in this field. There's to be no reason why he cannot continue doing what he's doing, making what he was making.
So what level are you talking about? How much an hour, or what's the math?
I don't know what I honestly don't know what he was making.
Well, also,
hold on. What order are we trying to modify, Mr. Asif? The relevant time period from the last order to now and the changed circumstances?
Yes, Your Honor. So the temporary order, so there's a temporary order in place in this case. Let me just draw the exact dates for you. So we have a temporary order on this modification action that's titled that was signed by this court on February 1st, 2024. No, my apologies, February 12th, 2024. It's called the Temporary Order Institute for Modification of Support Order and to Confirm Support Arrearage.
Well, that's okay, but that's still part of this lawsuit, which we're trying to modify what order, the final order prior to the
Yes,
temporary order?
so the order prior is the divorce decree. The order prior to that is the divorce decree that was the agreed final degree of divorce. I'm reading it now. It states that the court held this case on June 18th, 2021.
So that's the one we're trying to modify, the divorce of 2021? And they don't have findings about income in that one?
I'm reading it right now, Your Honor.
I assume it's a Hayes County divorce, or no?
Yes, this was in Hayes County.
Okay,
May I say something?
you may as well. What, ma'am?
Whenever the last time that we were seen in your court, you guys had came up with a monthly amount of $915. And then the medical portion, you were stating that if he was to pay if I was to continue to keep them on my insurance, it was close to $500 that he would have been paying. Because you guys was not going to allow him to make that full payment for the medical and dental
It's not us,
expense.
it's the family code that sets the parameters, ma'am. So we try to apply the law because that's our jobs. The state has a position, I may or may not agree with it. You have a position, I may or may not agree with it. But there is a cap on how much is considered reasonable, because you can go get the Cadillac of insurance and ask for $1,000 a month, but if the income is not there to support it as far as his income and the 9% gross of his income, that's what I'm required to follow. So just so you're aware of that. So what was your point of the temporary order?
What was pretty much set with the last court order, the temporary order. I'm asking that stays in place.
$915 in child support and $500 in medical support? Is that what you
Yes.
is that the case in that temporary order, Mr. Asif?
Yeah, those are the terms of the temporary order. That's correct.
Oh, and so it's Mr. Akko that wants some relief, whether it's temporary or final. And is he the one that's missing the documentation that you said we still need? You don't have W-2s or prior income from since the divorce?
Not from his
Can I
current
say
employer,
something,
Your
though?
Honor.
Not from his what?
Not from his current employer, Your Honor. We don't have anything with respect to that.
Well, it seems to me she's
I
arguing
just-
that he's underemployed, so all the income since the divorce is necessary to determine if he had a higher income and then is underemployed or not. But you wouldn't
And
have,
also, Your Honor, we're in. that
Mr.
was in
Asif, you wouldn't
Texas, and
have the
Cal-
W-2s or tax returns from what year was it? 2021, mid 2021 forward?
Reviewing our records, Your Honor, I don't believe we have. Oh, I see we have some pay stubs from 2023.
But you don't have, is there a reason there's no tax returns been brought by Mr. Akko?
I'm not. Oh, here we go. Okay, Your Honor, I see a W-2. Okay, I see a W-2 for the year of 2023 for
What
Mr.
about
Akko.
2022 and 2020?
So I have the W-2 for 2023 as well as a pay stub from dated August 25th, 2023.
But you don't have a W-2 or tax return for 2022?
Not for 2022, Your Honor.
Okay. Okay, what do you want to say, Mr. Akko, before I rudely interrupted you?
So the pay, no, I'm sorry, Your Honor. The pay from California and Texas is different than the pay here in Hawaii. So the pay for a meat cutter, I was making good money because my job title was a meat manager. And if there's no opportunity for a meat manager and the pay is different from California and Texas to Hawaii, the pay is a lot lower here in Hawaii. And there's not that much openings and opportunity for me to be a meat manager, considering there's like 1 million people on an island. So for me to go get a meat cutter job, the pays it's not going to be the same as the mainland. And what I was making in the mainland in Texas and California was wages as a meat manager, not a meat cutter. And honestly, what I'm making now, $22.15, is about the average as a meat cutter.
And
A
why?
meat cutter
Let's
here
just
only
find
makes
out. Why'd you
$22
move to
an hour.
Hawaii? What was required that you had to leave the mainland to go back to Hawaii?
Why did I go back to Hawaii to start a new life in Hawaii?
Cause what?
Me and my girlfriend decided to move to Hawaii. We decided to, start a life in Hawaii. So we went in Hawaii, and
I can't.
had a
I can't
job
hear you
at
anymore,
Foodland as
Mr.
a store
Octo.
director, and that didn't.
I missed some of your
Yes, can you hear
testimony
me?
because it was being staticky or garbled or something. It wasn't coming through clear. I didn't.
So your question is why did I move from Texas to go to Hawaii? Is because me and my girlfriend currently made a decision to move to Hawaii.
And you knew it was going to be a lower pay rate, or even with the
No, it
higher cost
wasn't.
of living, probably.
It wasn't a lower pay rate. It was about the same pay rate, because I went in at that time when we moved, I went as a store director at Foodland, and that did not work out with store director at Foodland. And then I went on and I went to another job at Whole Foods, which I got terminated, and I got a lawsuit against them. But that's where I'm at. And then right now, Mrs. Garcia is asking me for arrears just to plead my case. As far as April, the ending of April, I had a heart attack. So April the 30th, I had an open heart surgery that was not released from my doctor, from my physician, to August the 5th. I could not go to work. I could not retain work because, like I said, on April the 30th, I had a major open heart surgery.
Okay, I've heard enough complications that I don't think I'm going to be able to start and finish. I'm trying to get to the bottom line with y'all's arguments, but it's real clear to me that one, if she wants more because she thinks you're underemployed, then we need your wage information for all those years. Half of 21 after the divorce, all of 22 and 23, and whatever you have through 24. I need to see that. Did you file tax returns for the last 3 years?
No, I have not.
Were you employed at a salaried position?
Yes, I was. I did not file taxes.
So you got W-2s for each
Yes.
of those years?
Yes.
Why didn't you file for tax returns?
Because he felt like tax evasion and tax fraud was the next thing on his bucket list. And for those of you who are not familiar with Hawaii, absolutely gorgeous, gorgeous place. Very overpopulated in some parts. And there's a phrase about Hawaii from people that live there that they say priced out of paradise. They're moving to the mainland because they can't afford to live in their own state. And it's very unfortunate. Why he would choose to move there under those circumstances, I am just baffled. But it is gorgeous. And if you can find that niche job and keep it, in his case, more power to you.
I just didn't file. There's no excuse for me.
But you can retrieve 2021 W-2, 2022 W-2, and 2023 W-2s? I think
I can't get it right. I can't get it right now, but I can do my homework and get it.
And for
21, but
for 2024, whatever your comeback date is, you can get your last pay stub before you come back to court with the year-to-date information.
I told the attorney that I took a screenshot that I could send it to his phone with my screenshot, and he would have my current pay stub. With for some reason it's not going through with the email, but I took a screenshot, and I just said if he supply me with his cell phone, I can screenshot him my current pay stub.
Is there any other way to do it, Mr. Asif? Or
Your Honor, I would rather not disclose my personal cell phone number.
no?
Because what I make is, like I said, I make $900 something a month gross. After $200 taken out of taxes, my net is only $700 and something a week. That's all I bring home. That is it. I mean, I don't bring them anymore. I bring them in. That's what I make every single week.
Okay, that's your argument for another day. I'm trying to figure out how we can get not the screenshot, but your actual pay stub. You can't scan it.
I mean, I can try to email it again, Your Honor, but like I said,
well, how are you going to get the W-2s? How are you going to send those?
I don't have the W-2s in front of me. I have the pay stub, my current pay stub in front of me. The W-2s, I got to do my homework, and I got to call all my previous employers from 2021, 22, 23, and 20, and get all the W-2s and get those documents with me. I don't have the documents right now. Not saying to
well,
you,
whenever
I cannot
you
get it.
Whenever you get them,
you, but I don't have a copy of my current pay stub from Pepsi that says.
Whenever you get them, you do need to send
them in. But what I'm saying is, why should?
So,
but how fair is it for me to pay $915 a month, which I'm not making?
That's for me to decide after I hear all the evidence, but I don't have all the evidence. You don't have all the evidence. You don't want to come back, but I don't see how else to do it if you want me to hear it, and I don't kick you up to district court. Again, we already spent, 30 minutes on this, and I've gotten nowhere closer, 22 minutes to be exact. The state has an email where you send all this stuff, and you can't find a different device or a different way of scanning it, or going to somewhere that has better.
Well, like I said, I can send it again and see if it goes through again, but.
Well, it's too late for today. I don't need it for today. But when you send the W-2s, however you send them, you send that pay stub too, the year-to-date pay stub that's closer to the court.
I sent all my documents certified mail. I sent all my documents that you guys received as far as my doctor's note from my physician saying that when I'm supposed to go back to work, when I'm released. Every other documents I'm sending to you guys is certified mail, which I mailed it to you guys and you guys received it. So if I have to do the same thing with my W-2s and my pay stub, I will do that also. But right now, my thing is coming from is with Mrs. Garcia. I was making the same amount of money in California and Texas as a meat manager. I'm not a meat manager. There's not that much openings on the island that has.
You want to get to the argument of your case, and that's not where I'm at right now. So, Mr. Asif, have you received a certified mail envelope with all this stuff, and you still have it? I assume y'all don't get rid of documents, or at least not right away.
So I can confirm we have his W-2 for 2023. I can confirm that we have a pay stub from August of 2023 as well. Nothing as of today, I believe. Nothing with respect to what his wages would be from his current employer.
What about the medical records that he said he had, doctors, something or other?
Medical records pertaining to his heart condition. I'm not certain, Your Honor. Let me take a look, see.
Judge, FYI, screenshots can be emailed.
Thank you.
Okay, so I can email you the screenshot right now, correct?
Yes, sir.
Okay, so
what numbers are you going to use, Mr. Asif? Because, email, that's right. The CSD legal one?
That would
Let
be
me go
the
write the
appropriate one,
information.
yes.
Hold on for a moment, ma'am.
No, don't take your
What is
time
that?
doing it. I'm gonna set and give a different court date. I don't need it today. I need the one closer to another one. Do you have that one? Send it, fine, but not right now. That's gonna take too much time. Mr. Asif, did you find medical records? as part of the paper?
Pertaining to his condition, no, Your Honor. I'm looking through our records as we speak.
I sent you guys certified mail and you guys received it because you guys signed for it, stating that when I'm released, when was my surgery from Dr. Nakamura.
When did you do that? What day did you send it? Do you remember?
I sent it, man, I don't remember. I sent that maybe a month ago. I sent it with the documents that I had to fill out stating that, you know what I mean? Or it was a document from the court that it was 2 pages that I had to fill out and send it back to you guys, which I did that. And also I put in a copy of my paper from the physician saying that when I went in for surgery and what is my release date. I sent in a copy of my unemployment, which I applied for and got denied for it. I sent you guys a copy of that 2 pieces of paper from you guys, and somebody signed for it at the courthouse because it was at the child support office because I sent it certified mail.
Okay, when you say
And if you
courthouse,
want, I can
and you
show
said you send it to the AG, those
No.
are 2 different places,
I'm
Mr.
sorry.
Otto.
I sent it to the child support office and they have it.
Okay,
Somebody
they're
at the
not the
child
court, they're
support
not the
office signed
courthouse.
for it.
They have a different address. That's where you send it to their mailing address.
Okay.
You gotta separate us. They're
Yes.
not the same place.
Yes.
Okay, Mr. Asif, you're looking and looking, you still haven't found his
Okay.
medical?
No, Your Honor, I'm still looking.
Well, I can't wait for that either, but it would be important. Ms. Garcia, are you disputing that he even had a heart attack or open heart surgery? Is that gonna be an
No,
issue?
he had a heart attack, but just because he had a heart attack doesn't mean that his kids need stop. You know, it's going on. It's
But it
going
does
on
mean
9
that he
months
might
that I
not have
haven't
had
had.
income for a period of time. So do you?
Okay, then
You need
what's
to see
what's
those
the
medical
excuse
records or not, Ms. Garcia? To believe
What was that?
anything? You need to see those medical records?
For the heart attack?
Yes, ma'am.
I would like to see when he was actually released, to be honest with you.
Well, I would assume that would be a part of it. Mr. Akko, is that, you would have sent it after your hospitalization and it would have said what day you were released on?
And the documents that I sent to the court
To
from
the AG's office, not the
surgeon-
courts.
No, I'm sorry. The documents that I sent to the child support office specifically states what day I got operated on, what day, April the 30th, I got operated on, and it says specifically on August the 5th when I'm released to go back to work. That's
a
what it says
different
on the
date of-
documents.
A
But if
date
you
of
guys want, I
release
can-
from the hospital, is that part of the information that you sent? I assume so, that you didn't send it from a line in a hospital bed, did you? I mean, you waited till you got out and the records that you got would have had your discharge date. That's what she's asking for. Is that in there?
Not the only documents that I sent to the child support office, because she did not ask me for the information. The piece of paper that I sent to the child support office specifically states is when did I get operated on April the 30th and what day am I released to go back to work from the physician.
There's
because
an
she wants me to pay the arrears.
intervening date of no longer being in a hospital bed or in a hospital, and that would have been a discharge date from the hospital, not just a release date to go back to work. That should be part of your medical records. Are you saying it's just not? It skips from your heart surgery up to your release to work?
The reason why I send her the dates that I'm still not released from the doctor is because she's asking me for the arrears. That's the document.
Look, I get that, but one of the issues too is what date were you out of the hospital, and you can't tell me if you know that date or not. Do you understand?
I was in the hospital. I had surgery on April the 30th. I was released 5 days later.
You were only in the hospital 5 days.
5 days. Okay. 5 days later, I was released to the hospital.
Okay, you're under oath and you're on the record. So write that down, Ms. Garcia or State. Okay, Mr. Asif, no, nothing. You didn't find the medical records?
No, ma'am. We may have it, but I'm not certain.
Okay, well then help me pick a date to come back because it's already 4:20 and it's clear and you need more time than we've got today.
Yes, Your Honor. We have availability on our October 10th court date at 8:30.
Is there any reason y'all can't come back? And they have to be a priority, not at the end of the day, the
It'll
first
be,
thing.
yes,
I'm
Your
not
Honor.
gonna do this again.
I'll be sure to include in the reset order. It will be a priority hearing.
Then it should be well, it says 8:30 for y'all to come in, and if you need to share records at that point or whatever else, or talk for a minute, you can do that. But I show up at 9 o'clock to start a hearing. Well, actually, I'm here before then, but I won't start hearings till 9 o'clock when they're done with the.
Does that work in Hawaiian time?
No, because it's 5 hours behind you guys. So it will be, if it's 8:30, it would be at 3 o'clock in the morning.
We could do 10 a.m. as well. Our only
10:30?
docket times would be 8:30 and 10 a.m. Central Time.
So 10:30, our time would be what time his time? 5 o'clock?
5:30.
Your Honor, it would be 10 a.m. exactly.
Well, that would make
If
it 5 o'clock
it's
his
10:30
time.
on you guys' time, it's 5:30 on our time. It's 5 hours behind.
When did they show up today, Mr. Ossie, Mr. Ako?
I woke up at 5:30 in the morning. I woke up at 5 o'clock in the morning to go to court. And that's what time I woke up this morning to go to court.
So if I say 1 o'clock, that would be what time? 8?
7. No, 8.
8 o'clock your time. There's no reason you can't be up and on the computer by 8 a.m., correct?
Yes, correct.
Okay, then it'll be October 10th. In a few weeks on a Thursday at 1 o'clock p.m. as a priority. And that would give me enough time to hear it and hopefully get rid of other cases before y'all show up.
So from my knowledge, Your Honor, what kind of documents you need from me when I show up to court on the next month in October?
What we've been talking about, do I have to repeat W-2s for 2021, 2022? They said they have 2023, but if I were you, I'd send it again in case something happens to it. But 3 years worth, that would be the 3 years subsequent to after the divorce and the ones that you would have W-2s for.
So on that knowledge, Your Honor, I'm in Hawaii and the jobs that I worked at to attain the W-2s is all the way in California. And like I said, I would have to call the places that I work at to arrange them to send me a W-2s and arrange a copy of the W-2s.
You know who has your W-2s? The IRS, and you should have filed tax return. But they send W-2s to the IRS. I don't know if you can get it from them, but it's on you to try to find them. And that's why you're supposed to file taxes. You want me to consider your income. I don't know how you prove it and talk to somebody, but all I can tell you is if you have W-2s, you need to try to get them. They only have one so far. And then for this year, there is no W-2. You have to work till the end of the year and you won't get the W-2 till January next year. So for this year, your year-to-date pay stub, as close to the court date as possible, you email it.
So my question to you is, I want to know the logical behind it of 2021, 22, 23, when the bottom line is that that's all wages.
Because the last order that was entered that I'm trying to modify is the divorce decree from 2021. And what's relevant is all the time period since then. She's alleging you were making higher wages then and that you're underemployed now. Yes, I would have to see the higher wages. I'm not going to take her word for it or your word for it. I want to see what you actually made. And then for the pay stub helps me go through all the way to the court date so I can see obviously the lesser income now, but I have to buy into your argument that you had to move to Hawaii, you went underemployed or that you weren't underemployed and that you, I don't know what your reason is, but why you're not at the same job you were, and maybe your heart attack has something to do with it. I don't know. I've got to hear everything you present. And you need to have backup for everything you present, because I'm tired of this he says, she says that y'all don't really know what you're talking about. And I don't have any records. I'm just tired of it. And this case has been here long enough to where I think you need to provide documents, Mr. Ako. It's your income. Ms. Garcia, if you have anything else you can find, because if he doesn't show up with it, I'm not creating it. I can't get it for you. I am not your investigator. I'm your judge, but you have to provide evidence, not me for you. I don't have access to anything.
Your Honor, nobody told me at the last hearing that we was Honor that I gotta supply W-2s from
Well, I'm telling
2021.
you now because a big contested issue. And before y'all appeal me to another court, I want them to know I did my homework, that I required it, that I got to look at it, or whatever reason you may have is not available, that at least I forced you to try to bring it, because I'm not doing my job if I just say, okay, I'll take your word for it. No, I'm not. And Ms. Garcia, you're alleging something. I don't know if you can prove it or not if he doesn't, but on the other hand, it's your case to try to prove why he's underemployed too. And so understood. Okay, then I'm not repeating myself. And if you want me to consider your medical records and they don't have them, then I think you need to send them again, including your discharge date, or I assume nobody's going to dispute that he was only in the hospital 5 days anyway, if it doesn't show up on a piece of paper. So Mr. Asif, I'll ask your office, and I don't know what you do with all those things that are emailed to you, where they go, but I assume you don't dispose of them till the cases are over. So I'm hoping it's somewhere that you just can't access right now, but it's some screen somewhere that you can find. But talk to the AG. If they don't find it, then yeah, send it again. I'm sorry, but it's cheaper than trying to fly over here to go to district court. If you want me to hear it, I need some evidence. Is there anything else?
As far as a temporary order.
Yes, ma'am. I'm not
As far as
changing
the
anything. I
temporary-
don't have time to hear it anymore to change it, so it still goes on. However, Ms. Garcia, well, was it a contested hearing on the temporary order, or was y'all agreed to it?
It was
I
a
want
contested hearing, Your Honor.
It was? I don't even remember it, but okay, fine. I'll look for my records too.
I'm just asking
Anything
that it
else, Mr.
stays the
Asif?
same for right now.
You had your hand up, Mr. Asif. What else?
Your Honor, yes. May I retrieve my charger so I can charge my device?
Your what?
May I retrieve my charger, Your Honor?
Oh, yeah. So you don't get dismissed? Yes.
Thank you.
Judge, I'll update you with results. I gotta go.
Yeah, either tell me tomorrow or email.
Yeah,
me
tomorrow morning.
Yeah, that would be
before-
fine. Thank you, Ms. Gonzalez.
I'm sorry.
No problem. It's not an issue.
No, Your Honor, if I have to consult an attorney, how
Please
does that work?
do. That would help me if a lawyer.
Seems like,
What's the
now, can
question?
we extend this court date a little further for me to pay for an attorney and retain an attorney? Because I consulted with an attorney, and then he said that if it goes more than what it's supposed to go, and I'm under pressure to get whatever I need to get, that he'll be able to consult with him more.
Well, it doesn't bother me to set it later, so y'all are better prepared and have a lawyer. And it shouldn't bother you, Ms. Garcia, if you've got a temporary order in place that's not being changed. So is
If
there?
he has the money to consult with an attorney and hire an attorney, why is he having trouble paying his child support?
That's not the issue before me. The issue before me is if he can get a lawyer, I'd prefer him to get a lawyer to present actual evidence instead of him trying to flounder around and me trying to guess what's the truth is. So
Okay, so he's stalling right now. So I'm asking to keep the October 10th date because I have open enrollments and whatnot coming up, and it's starting in the end of October through December.
A court order trumps the open enrollment. If there's a court order and it orders something, then that's a qualifying event to start.
I'm the only one that's supporting our kids right now.
I get that, Ms. Garcia, but I'm telling you, a court order is a qualifying event. Even if you miss open enrollment, you can still.
Whenever you oversee an entire agency, that's my role. So that's why I'm October 10th. I have nothing going on that week but preparing, so that's doable.
How likely you get a lawyer? Just take more time to get back here, Mr. Rocco, without a lawyer.
Well, I just need to verify I just want to get as much information that, you know what I mean? That, and take the consideration that I was in open heart surgery, that I could not work, I was not released from the doctor. It's one thing that I was not, I was released from the doctor, but I was not released from the doctor. And that's why I sent that document to the child support office, because I want them to know from April the 30th to August the 5th, I was not able to go back to work. From the physician's standpoint, I was not released from the doctor to go back to work. So on that note, is why am I liable to pay my child support.
Your 45 minutes are up. I'm leaving. And Mr. Asif, do you have another recommended date? I'm going to move it from October 10th. If he can get a lawyer, I want him to. And I'm not talking about December or November, or maybe mid-November at the latest.
Yes, Your Honor. Let me just.
Your Honor, may I ask, why do you guys keep on giving him chance after chance? This isn't the first time that he's done this.
Ms. Garcia, you didn't. This is not the day to hear this case at 4:30 in the afternoon already. I'm barely
Well, I
starting.
understand that, but whenever you've dealt with a child going through cancer, you've dealt with a kid that was attacked by a dog, upon other health issues and whatnot, and I've been stuck to.
So you think
do
today,
everything
right
on
now,
my
I would
own?
have raised your child support and raised your medical support? You really think I would have do that today
No,
on
but what
a
I'm
limited
saying is
case?
that even the lack of support that he's been doing and I haven't been receiving, this isn't the first time.
This is not for payments. I'm gonna order how much is the right amount if the temporary order isn't right. So this is not about him paying or not paying. He's still required to do that under any order. This is about getting it right now, and you all are both arguing two extremes. And I don't have enough except your word right now, and that's why I'm requiring more evidence. And if I give more time for better evidence, it would be in your interest if you can bring, or he can't produce the records and you can versus the other way around. So I'm sorry, I've got to do what I've got to do, whether you like it or not. And right now I'm done. Mr. Asif, was there another date way before December?
Yes, Your Honor. I got logged out of my organization's VPN. May I retrieve my cellular device so I can log back in and retrieve the list of court dates?
Yes, sir, sure.
Thank you, Your Honor. Okay, we have availability on November 14th.
They're all Thursdays. That's when I hear Hayes cases for the party's information. And I could do the same thing at 1 o'clock as a priority, Mr.
We can't do 1 p.m., Your Honor. The only times we have available are 8:30 a.m. and 10 a.m. or 10:30 a.m.
No, that's because I set those times for my calendar, but I'm telling you, I want it at 1 o'clock so he can show up without having to wake up at 5 in the morning. Nobody else was asked to do that. And so that he's, I guess, hopefully clear-headed, and that we start because we finished the morning docket. So I don't care what your computer says or what anybody else says. My docket, I'm setting it as a priority at 1 o'clock. And
Yes, Your
I
Honor.
put the order to say that, and for y'all to be ready to go, don't negotiate 2 hours or 3 hours or 5 hours. I need to have it ready to go, and y'all prepared, everybody prepared at 1 o'clock on November 14th. And hopefully I will be done with all the other settings prior to that.
All right, so I would like to confirm that 9:15 is going to stand as well as the amount for the medical expenses.
I didn't touch the temporary order. I'm not changing it today. So right now it does continue under the last order, which is that's the temporary order. Then yes, ma'am, it does continue.
Okay, can I please make sure that the amount for the medical is included on top of that, please?
Mr. Asif, I don't know what the order says. I haven't read it. She's told me what she thinks it says. Are you confirming this, what she's just said?
Your Honor, if Ms. Garcia's position is for the terms of the temporary order to remain in place, I mean, that is precisely what's going to happen if you reset this.
Well, I don't agree with that. What happens if I don't agree with?
I'm
Because it's not
resetting
what
you
I'm-
so
I'm
you can
making
bring
law.
in evidence, even if you don't agree with it, because I'm not hearing it right now. It's too late to hear it. I'll be here till 10 o'clock tonight if I open the door to this, or even 8 o'clock. I'm not doing it. I've already had a very long day, and I'm very not
fair is that
I'm not
for me
able to
to
go
pay?
forward.
Then you know what? Let's just keep the October date because I'm not going to pay $900 something a month, which I'm on not
Okay,
making that
then
amount of
you
money.
do your homework, you get a lawyer as quick as you can if you're gonna do that, and you get your W-2s, and then we'll be ready to go October 10th at 1 o'clock. That's fine. And I'm not gonna repeat the order because I don't have the order, so whatever it says, it's a temporary order, ma'am. It's signed, it's on the record, it continues. I don't know what more you need to hear from me. I'm done. That concludes this hearing.
Here's the
Ma'am?
deal, because what happened was with the medical is that he was refusing to pay the amount. Well, the amount that you guys had ordered.
Ma'am, I reset it. Nothing
Well,
else you can say is
here's the
gonna
di-
change the order that's already in effect.
Oh my God. If you let me finish, please, because what we did is that we took the girls off of my insurance that they had been on, that I had been paying for previously, because he was not going to pay the amount that was being asked for. And he was able to get it cheaper through his employer, which was fine, but he can't hold down a job to keep the girls on insurance.
I'll hear it October 10th. I can't change it today, just like you don't want me to change the child support and he wants to change. I can't change it either way. I didn't finish hearing the evidence. I'm not going to finish hearing the evidence. I need to hear it on October 10th. I'll leave the
Okay,
original
can you
date
put something
at 1
in there,
o'clock.
at least $400 for the medical expenses for right now to be included? Because right now it's 800
I
and something
can't
dollars.
change the order without having a full-blown hearing. What part have you not understood, Ms. Garcia? I'm not going forward right now. So you get to keep the higher child support, then it gets to stay with whatever insurance is said. I haven't modified it yet. I haven't heard the evidence to modify it yet. I'm resetting this. That's all I'm doing is resetting it. So what's in effect is in effect, and I'll hear it October 10th at 1 o'clock. That's what I can tell you. Anything else, Mr. Asif?
Your Honor, I'm requesting that we hold the hearing at at either 8:30 or 10:30 a.m. Mr. Ako was the one who chose to move to Hawaii, knowing that he could possibly be in court for this. So I feel as if that would not be proper to have at 1 p.m.
Why not?
Mr. Ako was the one who chose to move to Hawaii, knowing that he had a court date.
I'm talking about my docket, Mr. Asif.
Yes, Your Honor.
Cases earlier might be 20 cases. I got to get those done before I talk to these people.
Yes, Your
If
Honor.
I talk to these people at 8:30 or 10:30, then I'm postponing 20 other cases. I can't do that either. This is my setting at 1 o'clock. I don't care that he's in Hawaii. I'm gonna let him sleep like everybody else gets to.
Yes, Your Honor.
So it's gonna stay at 1 o'clock whether the state objects or not. Anything else?
No, Your Honor.
I'm done. Bye. Y'all check out and we'll see you October 10th at 1 o'clock. You have any questions, you call the AG. You cannot call the court. And bring
That was
evidence,
October
both of you.
10th, Your Honor?
What?
Just to clarify the date, that was October 10th, Your Honor?
Yes, sir. October 10th at 1 o'clock.
Okay. Thank you, Your Honor.
The parties have exited the virtual courtroom. That concludes this hearing. I'll stop my recordings.
I don't think the judge has ever been happier to end a hearing than she was right there. Oh, holy cows. She's like, I'm done. Bye. It was equivalent to a rage quit. Oh, I know. That's why I showed you. Oh my gosh. This poor judge sees this day in and day out. I could make her the highlight of the channel. She never runs out of cases that are similar to this. I feel for her. I really do. Wow. Oh, that's why she was asking at the beginning, are you guys going to appeal this? Is there any reason for me to waste the court's time hearing this and making the orders just for you to say you don't agree? Which is exactly what's going to happen. She's going to make the modifications and then they're going to appeal it. They both said that they were going to appeal it. So why should she hear it? Oh, I know. Oh, I feel so sorry for her. It wasn't punishing him for having a heart attack, but that's essentially what comes down to at the end. I see your point. But he's not willing to pay his child support at all. They have a child with cancer. They have a child that was attacked by a dog. They have serious medical bills. And he's not helping because he moved somewhere and is getting $7 per hour less now than he was before. And his argument is it's only $7 an hour less. That's not going to change child support. Yes, it will. There are people who make wages of $7 an hour and have to live off of it. $7 an hour as a decrease in your pay is a significant amount. Oh. How do you know I can roll my R's? Speaking Spanish is very difficult for me. I only know a few words, but speaking Spanish is difficult for me because they speak from the front of their mouth and we speak from the back. That's the easiest way that I can explain it. You have to talk from the front of your mouth when speaking Spanish, and then that's how you're able to roll your R's and things like that. Romero. I don't know. I don't even know. But they're not Spanish, they're Hawaiian, so except the judge. Madrigal. Judge Dulce. Hey, quit biting me. That is my hand. I want my keyboard back. I don't want that tail slapping me. Oh. All right, the only thing I can do right now is use my mouse. So I'm going to use it. I know I have something more. I don't remember exactly what it is, but I know I have something more. I edited it. Oh yeah. Okay, the judge's camera is not working. It's all white screen. So I put the PAWFURM logo there.
Now calling case numbers 24T. Oh, wait, sorry. District Court is now in session. This is Magistrate Hillary Braley presiding. Now calling case numbers 24T00308. Also calling 19FB50. These are both the matters of Wardell Smith. Can I have appearances for the record, please?
Assistant Public Defender Sonia Chanel on behalf of Mr. Smith. Sir, state your full name for the record.
Wardell Smith Jr.
Okay, thank you. So today is the date and time set for an arraignment in the matter ending in 308. And what I am seeing here is that you were arraigned on the Monday the 2nd.
Yes.
And given a conditional bond with the domestic violence conditions that generally has no contact and a no go-to address. And I have a police report in here that indicates that you went to the place that you weren't supposed to go and had contact with the person you weren't supposed to contact. Also, it appears that you may have been under the influence of alcohol, which is also against one of the bond conditions. So, Attorney Chanel.
Thank you, Your Honor. We stand muted to the charges regarding bond. My client is 41 years old, Your Honor. He is gainfully employed doing landscaping work. In regards to the violation, my client did express that he needed to be at home to help his wife with their children. He also stated that he's trying to locate a new home for their family as their current house is being sold and they have to be out of their home by October 1st. Your Honor, I did re-explain the bond conditions. I do believe he will comply going forward. I don't see any other active cases nor holds, so we are asking for the personal recognizance bond to be continued. Thank you.
If I could say something, the reason why I went there early that morning. My wife called about my daughter. That's who I'm thinking called. I wasn't under the influence of alcohol. I went over there because inappropriate stuff. I had to search her room. She's
Okay,
19. No, I just want to be honest. She's 19. Searching her room. I'm just saying alleged. You know, ledge marijuana, a little dime bag, a little ledge that I found, and you know, so she was there. Why you searching my room? Why you searching my, because.
Well, Mr.
Then
Smith,
I
I'm
ended
gonna
up
stop you because
finding.
I can't let you keep going on the record like that. We in the middle of court, okay?
Oh, okay.
Okay, thank you.
Okay. So what the court is going to do, I'm pushing your pretrial date back to September 30th. So it'll be a pretrial and a bond violation hearing, September 30th, 2024. That will be at 9 in the morning over Zoom before Judge Washington.
You say you changed my pretrial hearing?
Yeah, it's going to be September 30th at 9 a.m. over Zoom.
Okay.
And at this time, while I realize that all of the bond conditions and the bond are largely being continued, I am going to reiterate everything, since it seems that you had some trouble with them the first time. So, to be extremely clear, you are not to use or possess alcohol, marijuana, or illegal drugs. You are not to purchase or possess firearms, ammunition, or other dangerous weapons. Within the next 24 hours, you are to report to community corrections for drug and alcohol testing. You will need $12 and a photo ID. Prior to your release from custody, you are to be fitted with a GPS tether with a hot zone of the address that you are not supposed to be at. You are not to have contact with LaTronda Smith. When the court says no contact, what the court means is no in-person contact, no contact through the mail, no contact over the phone via phone calls, text messages, emails, social media, the internet in any way, shape, or form, or through third parties. You are not to go to the Kansas Avenue address. When the court says do not go, the court does not care if you own the place, rent the place, or are personally invited by anyone to return to the place. You do not go.
Okay.
We'll have a hot zone that should help with that. You are not to engage in any sort of terrorizing, assaulting, threatening, harassing, molesting, or stalking behaviors towards LaTronda Smith or anyone else. You are not to engage in any sort of criminal activity whatsoever, and you are to appear for any and all dates set for you by the court. So that includes your bond violation and pretrial hearing set for September 30th at 9 a.m. over Zoom. That also means going to community corrections within 24 hours of your release. These conditions are being entered into the Law Enforcement Information Network. They should actually all be there already. And that means that if a police officer comes into contact with you and has probable cause to believe that you have violated one of these conditions, you are arrested on the spot and held for a bond violation hearing. And your bond conditions can be revoked and new, more restrictive ones set into place. So, at this time,
Will I have contact with my children? Can I still see my children?
Talking. You can let me finish.
Okay, I apologize.
Thank you. So, obviously, you didn't have a GPS tether before. You are going to have a GPS tether now. As far as the bond goes, at this time, the court will give you one more chance to get this right. We will continue the personal recognizance bond. That will be the $5,000 personal recognizance bond. So if we find ourselves in this situation again at that time, your bond will be $5,000. Okay. Now, as far as your wife and the other children, you have not at this time, it appears, been ordered not to have contact with any of them. You're not to have contact with LaTronda Smith. So how you work that out is up to you. But you can't go to Kansas Avenue address, and you can't have contact with LaTronda Smith. You can discuss details about that with the public defender.
Okay. Can my mother go get my children or my father?
One more thing, please.
Okay.
Stop. If you have things that you absolutely need to collect from that property, you may do so on a civil standby. So that means basically you call the police, they escort you to and from the property. Okay. Now, does that answer all of your questions?
Yes.
Okay. Thank you. Attorney Chenault, do you have anything else?
Yes, Your Honor. I would just like to add, if it's not already noted, third-party consensual contact for child care purposes. I believe that would be appropriate for him at this time if the court would allow it.
Okay. Thank you, Attorney Chenault. As I had not clarified all of the relationships here with the police report. Now, at this time, your client is not to go to the address and is not to have contact with any of the people who reside at the address.
Thank you for the clarification.
Thank you. Sir, your hearing is concluded. You are free to stand up until the jail that you are finished.
Okay. Thank you.
Thank you. Okay. Good morning. Give me just a moment. Sir, can I have your name, please?
Norman Johnson.
Mr. Johnson. So first, let me apologize. My camera is not working, so it's not, it's me. Are you able to hear me?
I'm sorry, I didn't get the last of that.
I said, it's not you, it's me. My camera doesn't work.
Okay.
Okay. So I have to be honest with you. The jail did not seem to know why you were coming in front of me, so I have no idea why you're coming in front of me today.
I have no idea. I have no idea either.
Okay, well, good. We are all collectively clueless. So, as pleasant as it has been to see you this morning, I don't have anything to do for you right now. We have a court date. It's in front of the judge on the 24th. Okay.
Correct.
Yeah. So I think you're supposed to see Judge Washington on the 24th. My court reporter's checking on that right now.
That's what I saw as well, Your Honor, because I didn't have an opportunity to speak with him.
So it sounds like the jail just decided that you missed me, so here you are. It's the 23rd, and it's in front of Judge Washington, correct? Okay, yes. So yeah, so your next court date for 14B is actually September 23rd, and it will be in front of Judge Washington. Okay?
Thank you. All right,
okay.
thank you.
Thank you. You're free to go. Good morning. Can I have your name, please?
Milton Ray Jr.
I'm sorry. Can you say that again, please?
Milton Ray Jr.
That's Mr. Milton Ray, Your Honor.
Okay, thank you. Okay. Now calling case number 248-159. This is the State of Michigan versus Milton Ray Jr. Can I have appearances for
Assistant Public Defender Sonia Chenault on behalf of Mr. Ray. Sir, state your full name for the record.
Okay. Thank you very much. So my understanding is that the public defender will only be representing you today for the purposes of this arraignment. So it seems that you have another attorney, Attorney Kareem Johnson. Is that correct?
Yeah, yes, yeah.
So what I am seeing is that you are in front of me today for an arraignment on a bench warrant. That would be for a community corrections bond violation. It means that you were ordered to report to community corrections within 24 hours of your release from jail. You were released from the Washtenaw County Jail on July 16th, and you did not report for intake or testing. There was no contact with you, and they didn't know what your status was. So, Attorney Chenault.
Thank you, Your Honor. We stand muted to the charges, and regarding the community corrections violation, my client did express that he didn't go there due to his aunt's funeral being that very next day. However, I did review his record. I didn't see any other pending matters or holds. I did re-explain his bond conditions to him, so we are asking for a personal bond at this time.
How did you understand him saying that?
Thank you.
Thank you. Okay. So at this time, the court is going to set a date for a bond violation and sentencing. That will be October 1st, 2024. That will be at 10 in the morning over Zoom before Judge Washington. At this time, all of the bond conditions are being continued, so you're ordered to community corrections. You're to go to community corrections within 24 hours of your release. None of your bond conditions are changing as far as that goes. Finally, your bond is going to be set at $25,000, 10% if allowed. Attorney Chanel, do you have anything else?
No, nothing further. Thank you.
Okay, thank you, sir. If you don't have any questions about anything that I just said, you are free to stand up and tell the jail that you are finished.
Okay, so you're released today?
So your bond is being set at $25,000. 10% is allowed. No. If you can post bond, then you can be released. You are free to go to the door and tell the jail that you are finished.
Ms. Dell, you had the opportunity to speak with Ms. Cozy. Ms. Cozy, was there any resolution in the matter?
No, Your Honor.
All righty. And so, ma'am, you had gotten a default in this matter. And in order to set aside a default, there has to be, what's that?
I'm sorry.
There has to be,
is it okay for me to speak?
yeah, I'm going to ask you some questions. Hang on for
Okay.
a second. And you filed a motion for to set aside the default judgment. And so I'm just going to go back to the you were personally served in this matter, and the second mailing was effectuated. Your case was set for the 12th, and judgment you failed to appear. Judgment by default was entered. Now, so I see you posted for the bond, but what I'm looking at in your motion is 1, good cause, and 2, an affidavit of meritorious defense. So, what was the? Just gotta scroll backwards. Hang on a second here. I see your motion to set it aside, and there's literally nothing attached to it and nothing written on there. It says, I asked the court, because the form says, I asked the court to set aside the default judgment, possession judgment. Motion must be made within 10 days of the default judgment because, and then there's space to put in what the because is. There's nothing there. In parentheses, it also says attach extra pages. There is no extra pages attached. There is no affidavit of meritorious defense. So those are all the things. Basically, there's like you owed rent. You allegedly owed rent. And now, if the other side wants to, because I guess Ms. Cozy, I guess my question is, she put $1,300 into escrow. I'm assuming she still owes rent.
Correct, Your Honor. As of today, her total balance is $5,675. Plaintiff would be requesting to proceed with the order of eviction that was requested. As stated, she does not have good cause for failure to appear and did not say the meritorious defense. So we'd be requesting that her motion be denied.
I don't even know what any of that is that you're saying meritorious offense. And as far as you saying that I didn't show up to court, what happened with the court proceeding is I logged into the Zoom meeting to do the court proceeding, and I made a mistake and I fell asleep. This is what like the true story is. I just got on nights. Can I just want to get it out because I feel like I it's like y'all saying stuff that I don't really understand. So I have to say my side at some point. I just started working nights. I've never worked nights ever in my life. So when I joined into the Zoom meeting, I made a mistake and I fell asleep. By the time I woke up and I tried to rejoin the meeting, it was already over. So I ran down to the courthouse and the lady was telling me the only way that I could do something about the judgment that was put in was to file a motion.
Okay. So anytime you file a motion to set aside a default judgment, there's two things that the court rule requires. As a matter of fact, it even says that I shall not grant a motion to set aside a default judgment unless there's two things. One, good cause. And the second is an affidavit of meritorious defense. What does that mean? An affidavit means it's a sworn statement that I swear to God this is true, notarized by a notary where that puts you under oath. And the good cause is like for you, you said your good cause was you fell asleep. Okay, so even if I assume that good cause is a good cause, because technically, I mean, I don't know, but let's just say it is. You still have to have the second part of it, which is an affidavit of meritorious defense. A meritorious defense means basically this. I would have won. I have all the things to show you that make that if we had actually done this case, I would have been the winner. Winner, winner, chicken dinner. I would have won this. And here's what
no one made me aware of an affidavit or anything like that. I don't.
It
When I
says
went
it
to
right.
the
It
court,
says it right.
the only thing she said was
says
to
it
do
right
was
on
to
the-
file a motion. I don't know what the paperwork
Sure.
is that you're talking about.
Sure. Well, what I'm saying is every party has to be held to the same standard, and that's the Michigan court rules. And I can't give you any legal advice because as a judge, I'm kind of like a referee. I can either blow the whistle or not blow the whistle, but I can't coach either team. What I'm saying is you have to have had an affidavit of meritorious defense. Do you owe back rent to Heritage Glen?
Correct.
All right, so by virtue of the fact that that's correct, there's no way you could have had an affidavit of meritorious defense, which means that they still had that rent owed to them either way. So there's no point in setting aside the case. If the case has already been determined and it was factually determined correctly. So there's no point in setting it aside, is what I'm saying. That's what an affidavit of meritorious defense is for. Because if we're gonna set aside a case, we gotta set it aside because there was a good chance that you could have won. There's no chance that you would have won because you did owe rent. They were suing you because you owed rent. So the only question is, did you owe rent and has it been paid? So that's what I'm saying. There's no reason to set it aside. Now,
okay.
If there's now the judgment itself is for the let me get back to that. Chronological order. Here we go. With costs is $4,200. You posted $1,300. Now, obviously, Ms. Cozy, you said that she currently owes because obviously September kicked in and there'd be the next month's rent. You say that the amount is
$5,675 what she owes as of today with September rent.
So $5,600. Now, if your case had been adjourned, if you had shown up and both parties had asked for it to be adjourned, it would still be, if we came to a resolution today, the amount that you owe, minus of course the $1,300 because you already paid that into escrow, would be that $5,600 and something minus the $1,300. So the only person who could actually say, you know what, I have no objection to setting it aside and discussing it and entering into a new consent judgment, or because they're going to have to file a whole new case because now they got September. So it's really up to Ms. Cozy how she wants to do it. That's why I put you guys in a room first, because if I set aside the default judgment, that means this case is still pending and I'm going to set aside that judgment. Now a new consent judgment can be entered into, which would include September without having to file a new case. But if Ms. Cozy prefers to file a new case, I also have grounds to just deny the motion. So, Ms. Cozy, which way would you want to do that?
Your Honor, we'd be requesting to proceed with the order of eviction that was submitted to the court and deny defendant's motion. We are not willing to give her any additional time to pay the balance.
All right, so I am going to note that the good cause and meritorious defense were not shown. The motion is denied, and the escrow is to be paid to plaintiff's attorney, which will be credited to your balance. And let's see, plaintiff for eviction filed, and the writ of eviction is being issued. And I'm going to modify the date of that to the 23rd of, well, so they should have a necessary clause. All right, so that writ will be effective on September 20th. So it gives her the next Friday to vacate the premises before you physically have to do that.
Your Honor, would you like us to?
I already put the order that I got right here. So. All right. You see that you had a proposed, that's just your response to their, okay. All right, so, and both parties will receive their true copy in the mail.
Thank you, Your Honor.
Yeah, I don't think she gets it. I think she's still lost. I think she feels like she's been wronged. Oh, that's all I got, you guys. That took me all day to find that. But I had so much fun with you guys. Oh my gosh. What a great night. And I didn't screw the editing up. Yes. Oh, I know. I know. She thought that was going to work. No. Oh, now you get to go back and watch it from the start. But wait, before you go, I have to give you something. Hello, Joe Punk. You didn't get that when you came in late. I'm sorry. And Allison, I love you so much. You make me smile. Oh, you guys have been so wonderful. Thank you. Even though Billy has this thing. He'll lay right in front of me, as you've noticed, but he especially does it if I have my phone right here in the middle. He'll do that all day long. If I'm doing anything, editing, it doesn't matter. If my phone is there, he lays over top of my phone. For one, then I don't know where it is because let's be real, Billy's a big boy. And for two, then I can't, be checking things and working on things. He's figured out, hey, she's not petting me or feeding me when she has that in her hands. So I'm going to lay on it and take it away from her. Yep. Buenas noches. I miss her. I haven't gotten to talk to her for so long. I texted her today and I sent her a Discord message. She's so busy, but I miss her. As soon as I get to hear from her, I will update y'all. You guys have been wonderful. Hello, Sir Philip from Maui, Victoria, Australia. Yeah, he hasn't gotten it yet. He hasn't gotten it yet. I won't put the buttons up on the desk because I don't want the work of transitioning the buttons from the desk to the floor and having him be confused and then go back to not using them. So it is where it is. Just need to get them to understand it. Oh, my kitties bite my fingers when I try to give him licky treats. Well, just Billy. Earl's the sweetest, most gentle kitty in the whole entire world, I swear. He really is. He is so gentle. And he doesn't have that like super scratchy tongue like a lot of cats have. His is really soft. He's a goofy kitty. I love him. Jody Gardner, I love you and I miss you and Papa Les so much. I hope life is going well. Yeah, I pick them up and put their little paws on it sometimes. Dang it, this is how it goes. All right, guys. Thank you all so much for coming out. I love every one of you. Be safe, be well, sleep sweet, and much love.